Well, our discussion up till now has spent a fair amount of time talking about theory, posing hypotheticals, asking abstract questions. This is where the rubber meets the road. We have three seasoned practitioners in the arts of budgeting who have personally lived, construed, and applied Silver versus Pataki. This is an extraordinary group of presenters. From my immediate right to left, Laura Anglin, and again, these are folks who really don't need an introduction. Ms. Anglin is currently the president of KeyQ, but in her life in public service, she is a former director of the budget. She is a former leading budget expert in the state legislature. She has seen Silver versus Pataki from both the executive and the legislative side. To her right, as well as another person who has seen it from both sides, Peter Kiernan, former counsel to Governor Paterson, who I think we heard the governor say not only kind things, but gave sage advice in the budget process. Peter, as well, in a past life, was a former counsel to a minority leader in the Senate. And to his right, Richard Brodsky, a former 14-term assemblyman who was an eyewitness to 28 or 27 different budgets, a battler for social justice, and a person who certainly says what he thinks, so you don't have to guess. I give it to you, Ms. Anglin. Please tell us about Silver versus Pataki in practice.
Good afternoon. So first of all, let me say I'm not an attorney, so I'm feeling a little outnumbered here today. So I really am going to talk from a layman's term about what the case meant for me as budget director, mainly in the Spitzer administration and a little bit going into Governor Paterson's administration. I also want to thank you, Governor, for bringing back all those terrific memories of the Great Recession. It was a time that I've not had to live through for 6 years, and I thought I was over it, but who knows what my nightmares might be tonight. So let me add that the governor did a great job highlighting a lot of the challenges that we went through, but you know, a lot of credit should be given to him. He held steadfast to make sure the state's finances held in order. Very difficult decisions were made, and I think history will remember him as the one that got the state through that crisis with no downgrades from the raters or any other issues. So we should all be very grateful to him. As Hank said, I have two perspectives on this case. I have the perspective from the legislature. I worked for the Assembly, ultimately as the budget director for the Ways and Means Committee for a couple of years, and then ultimately working for the executive. And I have to agree with the governor that when you work for the legislature, you're on one side, but once you start working for the executive with budget powers, you love Silver v. Pataki, and you just think it's terrific. So, but what does it really mean? You know, basic budgeting 101, the governor said the budget is about priorities, and that's really what it is. So as you're budgeting, you try to look at what the governor wants to accomplish in the year. But remember, the majority of the budget is not controversial. We have to pay DMV so that you can get your driver's license. The roads have to get plowed. So those aren't the issues that you're really focusing on. You're focusing on the higher level policy issues that come into decisions such as Silver v. Pataki when it happened. So as you're putting the budget together, you have to look at things such as fiscal implications, what is the fiscal health of the state, but also you have to look at, I called it a big chess game. What are the different pieces? You have to know as you're putting a budget together and what you want to get in the end, and what piece you'll need to move. What will the legislature want? What are you willing to trade? What are you willing to do? So it's really just not putting a whole bunch of appropriations together. It's really looking at a whole bunch of policy issues and also trying to figure out end games and positions. So if you're budget director or if you're governor, why would you want to use some of the powers under Silver v. Pataki? As the governor said, often policy decisions and budget decisions are very unpopular, but often may need to get done. Absent those, they won't get done, and it could take the legislature a very long time to agree on a budget. You don't want to make those tough decisions. Or perhaps the governor, as this governor did this year, he had a very strong policy agenda, probably one of the strongest that I've seen in many years. And then ultimately he felt very strongly that those were policies that he felt would be beneficial to the state, and hence wind up attaching many of them to appropriations. But one other reason, and I think it was touched on a little bit, is that it's also a way to prevent the legislature from really moving forward with doing a budget without you as governor. Right? So if you tie up very strong appropriations, or important appropriations such as school aid, and they really can't be changed or they have to be struck in entirety, you can't not fund school districts. So it really does tie the legislature's hand as to actually just ignoring your priorities and moving forward and doing their own. But there are limits to what a governor can do, and we talked a little bit about that today. So as you know, when we were putting the budget together, a couple of things. If you look at Silver v. Pataki, you can't just do this in a vacuum. You can't just decide to put whatever language you want in appropriation, because there are limits. I mean, the Constitution says each provision must relate in some particular appropriation in the bill. It must be limited in its operations to the appropriation to which it relates. So in the budget division, as you're putting together these priorities, and if you want to use this tool, you have to put a lot of thought into what language can go into appropriation and how it's related. So for example, if you want to increase the fares for the subways in New York City, always very unpopular. Governors do not like to do it. A lot of riders on the subways. You couldn't take that and put that in the school aid appropriation. That would make no sense, right? So you really, in the budget division, when we looked at this tool, we always took a lot of care to make sure that if we were going to do it, that it was going to have a tie to what you were putting it in, what appropriation you were putting in. And I think to not do that, our fear would have been that perhaps, we just talked about this on the last panel, perhaps there would be a challenge again to these powers, and I don't know, what would the outcome be? We had a little conversation about that. So I think we were very, very careful, and the budget division to this day is very careful to make sure that there is a relationship between policy initiatives and in appropriations. So let me talk about my experience with Silver v. Pataki, because when Bob called me and said, we want you to be on this panel, I go, you have the wrong budget director. And he says, well, why? And I said, well, let me give you a little bit of history. I was budget director for Elliott Spitzer. I worked on his transition team when he came in. However, as leading up to that, there were some constitutional amendments that were proposed. I think we talked a little bit about Prop 1 earlier, which was overwhelmingly voted down in 2005. But those had provisions that would change the balance of power, would change the fiscal year, it would provide a contingency budget, it would require certain appropriations to be done in a certain way. But one thing that people might not realize is, as that second passage was done, as you know, I think everyone in the room would know, for a constitutional amendment, it has to pass 2 separate legislators and go to the voters. As Prop 1 was being passed for a second time in 2005, prior to going to the voters in November, there was another bill that was introduced by the legislature and received first passage in 2005. And that bill would have actually been very strong in changing the balance of powers, because it would have required appropriations to be consistent with existing law. Any changes in proposed law would have to be done in separate legislation. It allowed the legislature to do more than reduce, strike, or accept appropriations if the governor's proposed budget was not consistent with current law. And that bill passed the Assembly on February 16, 2005, and passed the Senate on May 4, 2005, and was delivered to the Secretary of State. So that's 2005. Elliott gets elected in 2006. We have our first budget in 2007. And all of a sudden, everyone realizes we already have first passage. We're now in a separate legislature. So a conscious decision was made, and I mean a conscious decision was made, not to use any of the powers under Silver v. Pataki. And putting the budget together with a whole host of lawyers on the second floor who read every appropriation and would run downstairs and say, there's language in this appropriation, when it was typically regular exchange language or interchange language. We were very clear that they were not going to do it. And one step, we went even further. I think it was the first bill that was passed that year was budget reform. So we not only did not use Silver v. Pataki, but then we did a huge legislative reform, a 3-way agreement, did a big press conference, and that also really required more disclosure by the governor's office, more reporting, more interaction with the legislature. So I am probably the one budget director in recent history that had no experience with Silver v. Pataki, except to make sure that I didn't use it. So with that, thank you for letting me be here today.
Prior speakers have thanked all the sponsors for bringing us here. I'd like to thank Amtrak for bringing me here. I remember reading an article that said in 2010, the Paterson administration stumbled upon the technique of using budget extenders to get a budget. And I think the facts are otherwise. Just briefly, 49 of the 50 states have some form, either through statute or constitutional provision, have some form of a balanced budget requirement. In New York State, the governor has to submit a budget that is balanced on a cash basis in its general fund. But in almost no state is there really a balanced budget. The notion of a balanced budget is an illusion. And that is particularly true in New York State. I mean, Comptroller DiNapoli in his report, Deficit Shuffle, or my former colleague Carol O'Clarican, an economist who wrote Hidden in Plain Sight, talk about the phenomenon of deficits being masked by the movement of money in and out of different funds, in and out of the general fund, and other items of accounting ledger demand. The primary point I'm making, however, is that while there may be a perception that there is a requirement that a budget, balanced budget be enacted at the beginning of the year, fiscal year, there is no obligation and no perception that a budget has to be balanced at the end of a fiscal year. Now, calendar year, the significance of that is really demonstrated, I think, or was demonstrated in calendar year 2009. As has been remarked, calendar year 2009 was a very difficult year. It began badly with revenues falling through the floor. They never really recovered. In June of 2009, there was a coup in the Senate that paralyzed the legislature for a period of time. There was such ordinary extenders as the hotel and occupancy tax or county sales taxes, other kind of revenue measures were not enacted on time. That really led to a cumulative hit of about $1 billion to local governments. And the state deficit was increasing at an alarming rate. Governor Paterson spoke about that. So accordingly, in the fall of that year, Governor Paterson presented to the legislature a program to eliminate the gap, and having no obligation to act, not even an obligation to try to construct a facially balanced budget, the legislature refused to act. Now, Governor Paterson had not been elected. He didn't have necessarily have a strong political base or a wealth of political power. So we were always looking for ways of enhancing his institutional and legal power. The appointment of a lieutenant governor is a prominent example of that, but there were other like measures during the coup that didn't get much notice. For example, the governor sued the Senate to compel it to convene. The Senate had been having these dueling sessions. The Republicans would go into session and pretend that they were in control, and then right after that, the Democrats would go into session and similarly pretend. Well, the governor won summary judgment. And notably, just a couple days before that, the Senate Democrats had sued the Senate Republicans on similar issues, and the court threw that case out as a political case. But the governor also directed the state treasurer not to issue payroll checks Now, no one thought that the governor could do that because the treasurer was really just performing a ministerial act. But he did it. So I remember when so again, the governor was using untested measures to combat the fiscal crisis. And in October of 2009, that same year, the governor came to me and he asked me if he had the power to impound. So we did a lot of legal research. We consulted with constitutional experts, by the way, not the ones that opposed us in the lieutenant governor litigation. But I ultimately wrote a legal opinion saying he did have the power to impound. And as soon as I signed it, I directed that it be put into a locked drawer and never to see the light of day, unless the governor demanded it. He never did. But in the first 2 days of December 2009, there were two legally obliged payments that needed to be made. One was for Medicaid, and the other was for education, and the combined amount in excess of $2 billion, and those payments weren't made. They weren't made because there wasn't cash available to make them. The state was in a period of fiscal emergency, and even though that concept, that notion, doesn't appear anywhere in our laws or in our Constitution. So it shouldn't really come as a surprise to anyone that because we were always looking for ways of enhancing the governor's legal power, institutional power, to deal with the fiscal crisis, that we decided that he could use the lessons of Silver versus Pataki by putting policy language in extender appropriation bills. After all, the rules don't change just because you're in overtime. And one of the underpinnings of that legal advice to the governor was a lesson we drew from Silver versus Pataki, and the same lesson that we drew from the Ravitch litigation, which is that there is no intellectual power to the argument that, well, you've never done this before, therefore you can't do it. Governor Pataki did something that had never been done before. Governor Paterson did something that had never been done before. Now, I think there's a larger point here. There always is a tension between legislative power and executive power. There are no real defined limits of each. And I think that tension can be constructive, it's evolving, and I think it can be constructive. When Woodrow Wilson was a student, or excuse me, when he was a scholar at Princeton, he wrote a book in 1896 in which he predicted that the dominant figure in American government would be and should be the Speaker of the House. After the post-Watergate era, the Congress made a terrific grab for power as exemplified by the War Powers Act. President George W. Bush expanded power. His use of signing statements are just one example. President Obama is expanding power through sweeping executive orders. Governor Pataki expanded power. Governor Paterson saw the opportunity to expand power and did, and so has Andrew Cuomo. So this dynamic, to me, is a natural result of the system of government we have. There is nothing inherently wrong with it. To me, like you, many of you have been in the political and government business or are in that business. You know that you always strive for influence. You try to affect events. To me, Silver versus Pataki is just an example of that striving. I think it produces healthy results. And I don't think we should meddle with it meddle with that dynamic in a constitutional convention. Thank you.
Good afternoon. Let me start by thanking Greg and Albany Law and Hank for putting together an extraordinary program, but let me also take a minute to thank my colleagues. I started out in this business with Stanley Fink and Warren Anderson when there was a different attitude towards public service that was hard-earned and which ought not to be forgotten. And although I disagree with about everything I've heard, I am touched by the intelligence, strength of character, and professional skills on display today, and I'm privileged to be a small part of that. So to my colleagues, thank you. I'll touch on the practical elements here, but so much has gone on before that I do want to take a moment to remind us of Governor Paterson's admonition that we look at context and circumstance. America is a beacon of liberty across the world because we have legislatures. Everybody has a chief executive. There's a chief executive in Russia. There's one in Saudi Arabia. But what distinguishes the American experience is the ability of legislators to say no and to act as an independent center of power to counteract executive overreach. And I suggest to you that that is what is at the heart of the debate about Silver v. Pataki. If we lose the principled notion that there are separation of powers, there are checks and balances, there are reasons to enshrine the power of the legislative body even when the legislature is characterized wrongly as thieves and idiots. You know, I like to think of myself as a reasonably gregarious person. If you want to suffer loneliness, stand up before a group like this and defend the legislature. But the fact remains, that wasn't that funny, Hank. The fact remains that the principled question of the balanced check and circumstances by which power is exercised, as Governor Paterson told us, is at the heart of this. And what the Court of Appeals did was smash the conceptual notion of the separation of powers as it affects both budgetary and policy matters, and they are distinguishable. You know, I tried to come up with a name for this doctrine, the Smith doctrine, the Smith-Maguire doctrine, the Smith-Maguire-Anglin Kiernan doctrine. Yeah, it's the Putin doctrine. We have a chief executive. He'll decide, and the constraints on him will be political. Nonsense. As a matter of American history, as a matter of law, as a matter of constitutional doctrine, and as a matter of practical impact. The preservation of the legislature's powers to act are more important than the outcome of any single budgetary crisis or enactment. The question before the House has been to some degree masked because it's been put to you as a discussion about what are the powers of the governor. You know what? For the purposes of this argument, although I don't exactly mean this, I don't care. Let him put the gay marriage stuff in the budget. Let him put education aid in the budget. Okay. The question is, what can the legislature do about it? And what the contorted reading of the budgetary provisions of the Constitution did is it took from the legislature the power to amend. In other words, if these provisions were subject to normal and appropriate democratic checks, the legislature would look at it, yeah, I don't think so, and then amend. Even if I didn't like the outcome, the principled notion of a democratic society acting through elected representatives would be preserved, and the outcomes, by the way, in the long run would be better. To think that Silver v. Pataki has not had practical outcomes is obvious only to those who aren't school teachers about to get evaluated based on standardized testing in New York. Now, I have, with appropriate modesty, proposed a constitutional amendment. And I offer to you, I was in a column in the Times-Union, I've sent copies to the governor, the speaker, the majority leader, and it's been circulated, sort of. And it reads like this: notwithstanding any other provision of the Constitution, the legislature may accept, reject, or amend any submission by the governor. Now that's Democracy 101. And it leaves intact the notion of executive budgeting. Executive budgeting was never, here's my idea, saith the governor, and this will be the word. It was, here's what I think, what do you think? And the way legislatures exercise the what do you think is they amend. Now you can toy with the actual wording, and it probably needs some work. But if there's going to be a principled resolution of Silver v. Pataki that isn't Talmudic, well, in my sense, McGuire would say Aquinian.
Just political.
I defer to an expert. If there's going to be a resolution of the practical problems that is principled within the framework of American democracy, then I suggest that what I've proposed needs to be looked at seriously. Let me conclude then with, what's my little sign say, Bob? You're good? I'm good, okay. In practice, this is a ruinously important decision. And what the legislature does is it folds on things it cares about because it does not believe it has the power or the political will or political strength to sustain what the Court of Appeals, Judge Smith will correct me, I believe there's actual language in the decision that says the legislature's real power over the budget is power to delay. Have you tried that and then spoken to the New York Times editorial board? Or your constituencies? Look, we are at a point where if you care about outcomes, if you care about teacher evaluation, or other matters which governors are increasingly, and note the trend lines, the usage is, there's no reason to think all of a sudden it's going to go back like this. If you're concerned about the outcomes as much as you're concerned about the principled ways in which decisions are made, then there has to be a resolution of the unspoken and unanswered questions about Silver v. Pataki. And the question to Judge Smith, which I'll put before you now, is simpler than the question propounded by Hank, which is, what would you do if he put the gay marriage thing in the budget? You presented the example. How would you decide? That's the question that I would like to hear discussed. And I'll conclude then with a sense that the legislature has no political foundation upon which it can make the case that both process and outcome require the legislature to have the power to say no to the governor. That wound may be self-inflicted. But the interests of the state, the interest of governance, the interest of principled resolution of decisions and conflicts require two things. The governor maintain his preeminence in the offering of legislation, including the budget, that he have the ability to execute, but that the legislature maintain its historical and revolutionary capacity to say no to the governor. The notion that by stuffing a policy thing into what is normally viewed as an appropriation, that gimmick was intended to remove the policymaking powers of the legislature forever is no good. If you want to know why we're getting only extenders now, here's a practical consequence of Silver Pataki. Why would a governor negotiate an end of session package when if he doesn't like what he's hearing, all he has to do is wait until next March, stuff it in the budget, and it's going to become law? There is no longer any political rationale for normal legislative gubernatorial negotiations. We're in a crisis. We're in a crisis made by overreaching governors and a Court of Appeals decision that is problematic. And I urge, if nothing else, that whatever remedies come out of a constitutional convention or the constitutional actions of the legislature or public opinion recognize that democracy has always worked in this nation because of our faith in legislative bodies. Thank you.
I have just a few questions, and then we'll bring folks back and have the debate royale. Laura, I often think the public doesn't really appreciate the immense power, influence, and expertise of the division's budget. Not that I would characterize it as the hidden hand of state government, but it is peopled with extraordinarily talented, mostly career civil servants, probably as brilliant a collection of public servants as we have in New York State you can find in DOB. I understand governors come and go, and directors are direct reports to the governor, but I'm curious, is there an outlook, an orientation, a way of thinking about Silver versus Pataki institutionally in DOB that carries from administration to administration?
Yes, because just like governors go, budget directors usually go with governors. So I think it's a tool. So I think as every governor comes in and you wind up spending time getting to know that governor, getting to know what direction he or she would like to go into, it is a tool that is always there. And I can tell you, even when Eliot Spitzer did not want to use this tool because in fear of second passage of that constitutional amendment, which would have sent it to the voters in his first year, we were consistently thinking about, well, if we can't get this done or, we can't do this, then we had bills drafted that would do that. We consistently knew that that was something that was available. So I really think it's, what the governor wants to do, the political strength of the governor as well, because most of these things and most of the times when you use them are unpopular. Otherwise, you wouldn't be doing, unless, like Governor Paterson, you're in a fiscal crisis and you need the state to function and it's not functioning. So I think it's now part of the underlying thought process. It's part of options that we have to present. Because that's one thing that we'll always do is sit down with the governor, look at the political dynamics of a situation, and offer various options, and ultimately it's up to the governor's decision.
So, Peter, it's apropos of the division of budget. Not everyone in the public sort of knows the immense importance and the role of the counsel's office, and really one of the great jobs in all of state government is counsel to the governor. You, Judge McGuire, Charles Breitel. So many great legal luminaries have held that job. We sort of heard from Governor Paterson and you how you were continuously looking to assert authority where you thought you could. But did you recognize then and now, were there any limits? Could a governor go too far in Silver versus Pataki that you were mindful of?
Oh, I think absolutely. Firstly, there are times when the governor is just a clerk, executing executing the will of the legislature. And the role as clerk is at least half the governor's job, it seems to me. But in respect of limits and using something like Silver versus Pataki, my good friend Richard notwithstanding, I think, as Governor Paterson pointed out, he used the word time, but I would say on certain measures that were priorities of his administration, in 2010, such as selling wine in supermarkets and the obesity tax and a couple other things he mentioned, there just wasn't enough political support for them. I mean, had there been that political support, that might have passed in due course. So I think that the governors, any governor, has to recognize whether there is political support for the measures that she or he wants to put into a budget. And I think that notwithstanding all of the political power that Governor Cuomo aggregated in his first couple of years, I think he has, looks to me, I mean, you can never be more on the outside than a former counsel to the governor, I assure you, but it looks to me as if he recognized there's not enough political support for what he wanted to achieve, and so in the budget endgame, he backed off. And I think that's the case with other, will be the case with other governors, and has been the case with former governors, that they can't do things that don't have political support. And doesn't matter what tools they have. Those are the limits.
And Richard, let me push back ever so gently at your assertion that we're in crisis now. I think those of us who have watched Albany carefully over the last several decades know a crisis when we see it. We know, for example, for year after year, I think it's, 23 out of the last 31 years, we had late budgets as late as 50 days or more on average. And over the last 5 years, it would appear that Governor Cuomo has tamed the budget crisis. We now have 5 consecutive on-time budgets. The concerns that Silver versus Pataki was some awful thing, well, the electorate overwhelmingly voted down Prop 1. 65% voted no. What's the crisis when I think the public looks smilingly at a budget process that is getting done on time, efficiently?
I thank you for the correction. I meant a constitutional crisis. The political crisis probably doesn't exist because of the way these things have been framed. An on-time budget's okay. Ask the MTA about its capital plan. Ask whether the economic and social needs of the state are being met by these budgets is a much more important question than whether they're on time, in my judgment. I am a critic of a lot of what's been going on fiscally, because time and time again, governors, including Governor Paterson, Governor Spitzer, Governor Pataki, and Governor Cuomo, are not paying their wish list of expenditures with current and recurring revenues. Lieutenant Governor Ravitch is more articulate than I am on this. So the crisis is constitutional. This is not the way the system should work. It will yield bad results eventually. The fiscal and economic, fiscal and social policies embodied in budgets are not going to survive, in my judgment, long-term scrutiny. But yes, we got on-time budgets and everybody's happy.
So let me just then ask this follow-up question. I kind of think of Al Smith and Henry Simpson's view of the amendments in 27 as being captured by the observation that everybody loves a balanced budget, but nobody wants to do what it takes to make it happen. Well, it seems as though in 27, the electorate came to the conclusion that the legislature would not be mindful of the bottom line, that the centrifugal force of a legislative budgeting process would be to spend more and more and more money because individual legislators don't represent the state as a whole, but only their constituents in their immediate district. And so a process was created to build in a single person who would have to lose sleep at night worrying about balancing the budget, whereas the legislature wouldn't do that. And here we are nearly 90 years later, and it seems as though that process works from the perspective of we balance budgets and now we're balancing it on time. What's the constitutional crisis, your phrase, that needs to be addressed?
You couldn't have explained it better. The Constitution of New York does not enshrine the Austrian School of Economics theory of the sanctity of balanced budgets. That's Hank Greenberg's particular campaign, and you're entitled to that. There are economic theories of state expenditures and revenues that would differ from that, and the Constitution ought to allow for that. If the political and constitutional arrangements drive us to where you're going, they are inadequate to other crises and times, not just the ones Peter and David Paterson had to go through.
Well, why don't we do this? Why don't we bring back Judges McGuire and Smith? I'm going to pull the podium back. We'll open up the floor. I'll start it off with a question or two, and then we'd ask all of you, if you have any questions, to come down to the microphone.